Coming on Law Weekly today, lawyers react to the move by the Senate to amend the Code of Conduct Bureau and Tribunal Act. Also showing on the program, a chat with the chair of the Chartered Institute of Arbitrators Nigeria, Mrs. Adedoyin Rhodes-Vival, plus our weekly recap of the top legal stories in the news. That's the lineup for this edition of Law Weekly. Hello and welcome. I am Shola Shuyeli. Our Vox Pop shows sadly that very many people know little about arbitration. And so let's go straight away to our chat with the chair of the Chartered Institute of Arbitrators Nigeria. I began by asking Mrs. Adedoyin Rhodes-Vival what arbitration is and why the laws on arbitration is generally regarded as obsolete.
I think to say that Nigeria's arbitration laws are obsolete is a general statement, and that wouldn't be fair. The arbitration law of Lagos State is very up-to-date. That's a recently enacted law. But unfortunately, on our statute books, we still have the old ordinance-based laws. They were enacted in 1914. They are based on the English Arbitration Act of 1889. And some of the states of Nigeria still have those laws on their statute books. With respect to the Federal Arbitration Act, that was passed in 1988. When it was passed, it was a very modern law. It was based on the UNCITRAL model law on arbitration. In fact, Nigeria was the first country in Africa to adopt the UNCITRAL model law. But since then, the UNCITRAL model law has been revised. It's been revised to take account of new developments. But that law act still remains on our statute books, which is very unfortunate. And if we can appreciate how unfortunate it is if we begin to appreciate the interrelationship between arbitration and economic development. You see, arbitration is the preferred means of resolving international disputes. When an investor is about to invest in any country, one of the key issues that they first ask themselves is, does this country have a strong and supportive judiciary to arbitration? Are there effective means of resolving disputes outside the court system? And you can well understand that. You are a Nigerian. If you are entering into a dispute with even a fellow African, would you be happy subjecting yourself to the court of that fellow African? Or would you rather prefer being subject to the courts of your own country? Or better still, will those parties not prefer a neutral venue? And that's what arbitration is about. It gives parties the opportunity of resolving their disputes in forums that are not tied to their own country, so they can have a feeling that they are in an independent and neutral venue. So when you see a situation where you have a country that has a developed regulatory framework for arbitration and a conducive environment for the practice of arbitration, you'll find that that country becomes a preferred seat for arbitration. And with it becoming a preferred seat for arbitration, it also attracts invisible earnings into that country. All the major countries of the world have done that. UK is a very favorable place for arbitration. You have New York, you have Geneva. You have some new emerging countries that have also positioned themselves.
How do you think Nigeria is positioned, though, as a destination for international commercial arbitration?
Well, Nigeria has many things going for it, but there's still a lot we have to do. We need to do something about our arbitration laws. The ordinance-based arbitration laws should be expunged from the statute books. All the states should begin to enact up-to-date arbitration laws. The Federal Arbitration Act, Arbitration and Conciliation Act of Nigeria, needs to be revised in line with the latest UNCITRAL model law, 2006, and the latest UNCITRAL arbitration rules. Nigeria is a party to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which makes it easy to enforce an arbitration award, right? So that's a plus going for us. But then we also have the disadvantage of the amount of time within which disputes get locked up in the court system. We all know our courts are congested because, sadly enough, Nigerians have become very litigious. Litigation was not a traditional method of resolving our disputes. African countries, they arbitrate or they mediate their disputes. That's the African traditional way. But with the advent of the court system that was imported by the British, our disputes have been put into the court system. There are too many cases tied up in the court system. Nigerians are yet to fully appreciate the advantages and benefits of mediation to enable these disputes to be taken out of the court system. So the delays in the court system can and does impact negatively on arbitration. Thankfully, we have a number of cases that are coming out of our courts that arbitration disposed. But we need to do something about the length of time within which it takes a case to go through the court system, because arbitration still needs the court support. For instance, if you get an award in your favor, you need the court support to enforce that award. If you get an award that you believe, you genuinely believe, and I want to say genuinely now, you genuinely believe should be set aside for some reason or the other in accordance with the relevant statutes, you need the support of the courts. During the process, you also need the support of the courts. For instance, if you want to subpoena a witness, arbitrators are not backed by the state, so they don't have that power to subpoena third parties. Arbitration is a private agreement between parties that if a dispute occurs, we'll resolve it through arbitration. They don't have the state-backed mechanism of the courts. You still need the courts. So something has to be done about giving arbitration a special status within the court system. For instance, when an arbitration agreement application has to be filed in court, does it have to go through the High Court, Court of Appeal, Supreme Court? It takes time. There's some people, and I also have a case like that, that's taking so long for us to go through the court system. But it's because the courts are congested. So if either specialized courts are set up for arbitration matters, which will even develop expertise, the judges that are handling those arbitration matters in the specialized courts will get more familiar with arbitration. They'll become specialist arbitration judges, and that will also help.
When the arbitration laws are revised, will it take care of all of these issues?
For instance, revising the arbitration law will only take care of certain issues of the practice of arbitration itself, because the Arbitration Act regulates arbitration itself. But there are other things that you will still need to do in order to get us to where we should get ourselves to. There are also some laws that also impact negatively on arbitration that we could do something about. And I'll give you an example. The Legal Practitioners Act tells you who a legal practitioner is, who can practice as a legal practitioner in Nigeria, which is understandable. It must regulate the practice of legal practitioners. But the reality is that a country that wants to develop and be accepted as the preferred place of arbitration must be a country that allows foreign practitioners to come in to act as counsel in arbitration proceedings.
Let me take you back to something you said earlier about the laws. Whose responsibility is it to revise the arbitration laws?
That's to start from the lawyers will get together on it, and eventually it has to be passed as an act of government, the legislature. But we have a stakeholders committee, and we're already working on it. And when we finish, we've done extensive work. In fact, many years ago, when Chief Ojo was Attorney General, he set up a committee headed by Justice Orojo to look into ways of modernizing Nigeria's arbitration, modernizing the Federal Arbitration and Conciliation Act. We did a lot of work, a lot of extensive work. We advocated various reforms to bring the law in line with modern developments. But unfortunately, that law has not been passed. But we are still on it. Last week, we had a stakeholders meeting. We are working on what we are going to be advocating to be passed as a revised Arbitration Act. But it's still the legislature that has to do it. And we are hoping that this will be done.
We've been hearing about arbitration for a very long time now, but the mindset of the average Nigerian is still litigation-based. This is something that you also alluded to, go to court and all of that. Whereas arbitration is touted to be cheaper and faster, why do you think that it hasn't really caught on with the litigating public?
You see, there are many reasons. I wouldn't say it hasn't caught on, because there are many contracts. There are many commercial contracts that include arbitration clauses. But even then, including an arbitration clause is not enough. Have you included a properly drafted arbitration clause? For instance, there's something we call pathological clause. That's not clear. is full of inconsistencies. It's not a workable clause. And eventually, maybe the clause refers to a non-existent institution. Or the court just says, any disputes arise shall be resolved by arbitration. And then a dispute arises, how do you appoint your arbitrator? You might end up going to the court. But if you have a properly drafted clause, it will tell you that, it will tell you so many things. It will tell you the mode of appointing your arbitrators. It will tell you that if you don't agree on that, if you cannot agree, you can get a third party. Usually you put an arbitral institution to appoint, to be the appointing body. Because if you don't put the appointing, if you don't stipulate that an arbitral institution is the appointing body, you're going to end up in the courts. So you've added to the number of litigations going on in court. So there are many reasons for it. And then there's some lawyers that don't appreciate that the fact that they have agreed, they have assisted their clients in incorporating an arbitration clause does not mean they will not, in fact, that they have not assisted their clients in incorporating a properly considered dispute resolution clause does not mean their income is being taken away from them. Because apart from the arbitration clause, we also have the clauses that are multi-tiered, which are also the even better clauses that if a dispute arises, instead of going straight to arbitration, you try and resolve it internally between yourselves. If you're not able to resolve it internally, then you can go to a third party to assist you in resolving it through mediation. And then you give yourself a certain stipulated time within which to mediate. And then if you cannot mediate, you can now go to arbitration. So many clauses, it takes a lawyer to advise his or her client that, look, instead of just leaving the issue of a dispute arising without any solution, why don't we put a multi-tiered dispute resolution clause? So it's just to get people to be more aware and to also be more aware in a way that they act in good faith when the disputes arise. They don't bring objections to setting up the tribunal. They don't get to court and start bringing all kinds of spurious applications. They don't get to the arbitration tribunal and start for some spurious reason or any other reason that is not an appropriate reason. Avoid arbitrating that dispute.
What's the role of women and young lawyers in arbitration?
Young lawyers have a role so long as they want to practice arbitration and they want to learn, they want to develop the skill. They have to get trained. In fact, the Chartered Institute, its mandate is its focus, its mission, its emphasis is on training, education, qualification, and ethics. We want to develop, the key mandate of the Institute is to develop a learned society in the field of arbitration. So if you want to become a learned member of the arbitral community, then the Institute is where you should come to. And as for women, women also have a role. There's no gender discrimination in arbitration. But there's been more focus now on ensuring that women are equally represented. Because from statistics all over the world, it appears that women are underrepresented. So there's this ERA pledge that many arbitral institutions have been keen into, which is basically them affirming that they'll ensure that in appointments, in seminars, conferences, they'll always ensure that they have women equally represented as the men.
Thank you very much.
And we have many notable women arbitration practitioners.
Arbitration offers a quicker and more confidential dispute resolution alternative to litigation. It's also the preferred choice of investors for commercial disputes, and so Nigeria needs to amend its obsolete laws and bring it at par with international standards. These are some of the views expressed by my guest, Mrs. Rhodes Vival. As usual, I'll take your comments and feedback via any of our social media platforms. But still ahead on the program, lawyers react to the amendment of the Code of Conduct Tribunal, as well as other top trending stories from the courts.